So I'd like to get started by introducing our panelists for tonight. Our first, and please excuse my pronunciations. I'm not from Boston, and some of these words that I'm about to read are a little bit difficult for a Midwesterner such as myself. Our first panelist here tonight is Tackey Chan, who graduated from Brandeis in 1995. He is currently the state representative for the 2nd Norfolk District, including 13 of the 30 precincts in Quincy, Massachusetts. Tackey is a lifelong resident of Quincy, having first been elected to the Massachusetts House of Representatives in 2010 and is currently serving his 6th term in office. He was one of 3 representatives elected in 2010 of Asian descent, making him one of the first Asian Americans elected to the Massachusetts House of Representatives and the first Asian American and person of color elected to office in the city of Quincy. He is currently serving as chairman of the Joint Committee on Consumer Protection and Professional Licensure. Our next panelist is Karen Loewy, who graduated from Brandeis in 1996. She is senior counsel for Lambda Legal, the oldest and largest national legal organization committed to achieving full recognition of the civil rights of lesbians, gay men, bisexuals, transgender people, and those with HIV. She handles groundbreaking litigation and supervises attorneys in all areas of Lambda Legal's work, including fighting for recognition of same-sex relationships, battling anti-LGBT discrimination in employment, housing, public accommodations, and healthcare, and securing the rights of LGBT parents. Prior to joining Lambda Legal, Ms. Loewy was a senior staff attorney with GLBTQ Legal Advocates and Defenders, also known as GLAD, where she engaged in a wide range of LGBT impact litigation and policy work throughout New England for nearly 12 years. Our final panelist is Matthew Siegel, who graduated from Brandeis in 1999. He is the legal director of the ACLU of Massachusetts, where he leads a team of civil rights lawyers. His cases at the ACLU have temporarily halted former President Trump's first Muslim ban, dismissed over 60,000 drug charges in the Sonia Farrick and Annie Dukin lab scandals, affirmed the right to record police officers performing their duties in public, and resulted in the release of over 6,000 people from jails and prisons due to the COVID-19 pandemic. Matthew earned his JD from Yale Law School and his BA in Mathematics and Sociology from Brandeis University. I am very excited that they have given their time tonight to tell us all about how Brandeis helped launch these very inspiring careers and how recent changes in the world have impacted what the work they're doing. So the first question I'm sure many of us are wondering, as most of us are Brandeis alumni ourselves, how did Brandeis set you up to pursue a career in social justice? I know a lot of people who go there are already, moving in that direction or very passionate about it, but how did your experiences at Brandeis set you up for that? And let's start with Karen.
Sure, thanks, Myka. So I was one of those people who was pretty social justice minded when I got there, but in truth, I had not been thinking of it as a career. The odd answer is that the way Brandeis actually put me on that path was the ability to double count classes towards majors and concentrations. My majors were Negis and music, but my approaches to each were really feminist and legal. So I was taking Women in the Bible with Mark Brettler and classes on Jewish women in feminism with Joyce Antler and Talmud with Reuven Kemmelman. So doing that in my majors gave me the building blocks of both legal studies and women's studies concentrations, which really led me to take classes that made clear that my particular route to social justice work was law school. Most prominently, I think, what was then the Introduction to the Women's Studies concentration, at the time taught by Jill Lynn Fellman, which really introduced me to queer theory and gave me language and frameworks for my feminism, the fluidity of gender, understandings of patriarchy and misogyny in the best ways that only, really a great liberal arts education immerses you in. I took First Amendment classes. I took a great sex discrimination in the law class. And really all of these really put me on the path towards eventually going to law school and doing the work that I do.
Thank you, Karen. I'd love to hear from Matthew next.
Thanks. Hi, everybody. Nice to see you all. Thanks for joining us. Thanks especially to my dad. Thank you for the support. Appreciate it. He's here, and also a Brandeis grad. Very similar to Karen. I mean, I studied sociology at Brandeis. I took classes from Gordy Fellman and the rest of the folks in the sociology department, and I think that that had the effect on me that you'd expect to have, which is it caused me to care, I think, more about people and see things from their perspective and see and understand injustice in a way that I might not otherwise have done, but also caused me to think more about the impact. What is, when we often think of injustice in terms of impact, what is causing this harm? What is causing things to be bad? What is causing things to be unfair or unequal? But if you're choosing a career, I mean, you're not setting out to do those things. You're setting out, if anything, to prepare those things. And you have to think about what kind of a positive impact you can have. And I think that's really difficult for anyone, but particularly for someone who's trying to use the law in a helpful way. And I think that Gordy and the other sociology professors that I had really helped me to think about how to make a positive change and how to assess things by whether that was happening. The other thing I would say is I took math, and nobody ever, everyone always assumes that that's just sort of like a thing that I dropped. But and in a way I did, because I didn't really think I was going to make a huge impact in the world of mathematics. But I will say, I feel like I use math every day in my work. And that's because, I mean, the law is really an attempt, often an imperfect attempt, but an attempt to create rules and logic that will govern our society fairly. And a lot of what I do is figuring out when that's not working, and what can be done, if anything, to fix it. And I try to do that through logic, through problem solving, and through reasoning. And maybe I'm successful, maybe I'm not, but I feel like when I am successful, I'm using not only the skills, the sociological skills that I tried to learn from my professors at Brandeis, but also the mathematical skills. So I really think both of those things have been tremendously helpful to me as someone working on social justice.
Thank you, Matthew. And if we're shouting out parents, I got to shout out my dad, who's also here. I don't know if any of the other panelists have parents or family members.
Yep, my parents are on too.
Great. Thank you, parents, for supporting us. I'd also like to echo Matthew's comments. One of our jokes in law school was, they told us we wouldn't have to do math. That's why we're here. And I also use math every day and had to present to a judge some interest calculations this morning. So I can definitely relate, and probably would have been better for me if I'd taken more math classes like you at Brandeis. Tackey, I'd love to turn to you at this point.
My mom's in the kitchen, so I know where she is. She ain't on the call. Appreciate you all having me here tonight to talk. Social justice with me is kind of an afterthought of Brandeis. I never really thought about the impact of Brandeis until I got a little bit older. And same thing at BC High, Boston College High School, where I got my high school degree, and never thought about it too, because their motto there is meant for others. It's actually the motto for the school. And I actually got my degree in politics, and I'm trying to make my degree work for me somehow. So figure that one out. But it's a business trying to be helpful is what I got into. And turns out I'm actually not bad at what I do. So I stuck with it. And law school, to be honest with you, was a career move issue, because it's much fun working the legislature as an aide. You need a career after being an aide. So law school was an opportunity to open up opportunities on how to apply law, because I spent a lot of time writing laws, but I don't know how to read case law. And actually at New England Law School, which used to be known as the Portia Law School, if you know your Shakespeare, was the first law school for women. And the reason I went is because there weren't many night schools available. So it's a working class law school. And from there, met a lot of very interesting people in night school. It's very different from daytime. And learned a lot about their different issues in life, and realizing that people are here to make a difference going to law school. So I think for my case, getting to the legal field was actually just a continuation of things I never realized I was doing as a result of my upbringing at Brandeis and my upbringing at BC High. And enough, strangely, my upbringing in New England Law School kind of accumulated to me being me, not knowing that I'm doing, social justice work, trying to be helpful to folks, giving away way too much free legal advice, which I think everybody here has done more than one time, and kind of just trying to figure out how to look out for people that need an extra voice out there. I don't think I consciously knew I was doing this until, really until my mid-30s. I'm like, oh, this is what happened. And, I'm still kicking around doing this today.
Thank you. I'd like to go a little bit deeper on this topic because I know for my own experience, I felt very supported in social justice causes at Brandeis, and I felt less supported in those causes once I went to law school. And just having talked to friends and colleagues who also attended different law schools, it felt like law school was not a place that generally supported social justice and helping people. Can you all speak to whether you had similar experiences, and if so, how did you make it through law school still knowing that you wanted to help people at the end? And let's start again back with Karen, please.
Thanks, Myka. So I was very lucky in some ways because I went to Fordham Law School in New York, and particularly among the reasons that I chose to go there was that I was part of something called the Stein Scholars Program for Public Interest Law and Ethics. And as a Stein Scholar, it's so easy, I think, within the law school community to get sort of caught up in the competition and the who's going to go where and make the most money. And the Stein Scholars Program really gave me a built-in community of folks who were similarly minded. I was very lucky to actually have a couple of other Stein Scholars. And when I say lucky, like there were like 20 Stein Scholars per incoming class. So I was lucky that there were 3 others in my 1L section, which was really oddly disproportionate and very, very helpful. And they, just continued to be my community throughout, so that whenever it felt like that kind of ethos was overtaking, where you just were clearly there for very different reasons than lots of other folks, to have that sort of that community and that sounding board was super helpful. I'll also say that I did not take the most practical course through law school. I was the one taking, I was taking things like, feminist and critical race theory, and I was taking the civil rights clinic, and which that was practical. That was definitely practical. But, whereas folks were taking domestic relations law, which was much more nuts and bolts, I was taking family law and policy. So I was seeking out, even within the law school community, the classes where I knew I was going to find the others who were going to engage in legal debate and legal learning through similar lenses to what I was trying to do.
Thank you, Karen. Matthew.
Well, I mean, I wish I could say that I had a plan and I executed the plan, but I didn't really. So what ended up happening is I spent, I think, most of law school thinking that I would never really practice law. I mean, just, I kind of went through it like it was 17th, 18th, and 19th grade. I was there to learn and take exams and things like that. And I didn't really have a plan. But over time, I think I got a better sense of a couple things. One was that I actually liked practicing law, which I wasn't sure would be the case. And then over time, I think I got a better sense of how I believed I could apply the law to help people. So I worked for a bit at law firms, but then I went to North Carolina, moved with my family there, and worked at a federal defender's office for 4 years, representing poor folks accused of federal crimes. And I think that experience doing direct representation was very helpful to me in understanding some of the injustices of the criminal legal system, both in general and particularly in terms of racial justice, but also showed me, I think, some of the limits of direct representation, particularly in criminal court. You know, I represented people, they'd already been convicted. I appealed their cases, their sentences, their convictions. And for the most part, I did not win. And when I did not win, not only did their lives not improve, but maybe other people's lives didn't improve because there was a precedent that was created that would not only close the door on my client, but on other people who are similarly situated. So I kind of felt like it would be helpful to take a job with more tools in the toolkit where I could litigate in different ways, be in criminal court, be in civil court, do public education, do media, do public advocacy, do litigation, and try different ways around to navigate a problem. And that's one reason why I went to the ACLU. I thought that there was a real opportunity to make a difference through that work, not just doing impact litigation, but all the different kinds of ways of doing advocacy and trying to make a difference that the law allows.
Thank you, Matthew. Tackey, I know you already addressed this a little bit in your last answer, but do you have anything else you wanted to add about the differences between your experience at Brandeis and then at law school?
I think it's a pressure issue. When I was at Brandeis, I was doing a lot of school, but also was working a lot of jobs part-time to get by. Night school was a little different kind of pressure because you had a day job. In my instance, I was trying to start a not-for-profit agency. I was doing a lot of other community work and sitting on boards, and it became a prioritization issue in law school for me. And I wasn't the only one, obviously, in night classes with people with family, with kids. We had people who were actually pregnant in law school the first year, which I give them more kudos than anybody trying to do that in law school at night. And it was just a struggle of just getting used to law school was the hard part, to be honest with you. I still couldn't read case law properly to year 2.5, was I started figuring it out. But you had to kind of stick with it. And, my class was like 120. We lost 20 people in the first month. And I think I was in a class of like 65-ish by the time I graduated 4 years later. So, I wasn't exactly seeking social justice. I was just trying to survive at one point to get to the end. And, a lot of other people were in the same position I was in. So, of course, there's the bar exam, which was equally more scary than law school, in my mind. On top of that, I think a lot of the applications of law school, in terms of social justice and how I do my job became extraordinarily valuable. I think the analytical skills, the way I approach things, the way I can look at things at different angles, I largely credit to going to law school in what I do today, whether it be a constituent case about not finding housing or working on, complicated issue like security breaches and doing security breach law and privacy issues. So at the time of, it was just living through it. Afterwards is when a lot of practical application came in.
Thank you. All three of you now do impact work. Once you had decided to go into law, how did you decide between doing direct representation of clients and impact work that would make broad social change for a lot of people? And Matthew, you already started to address this in your last answer, so I would love to start with you and have you elaborate a little on how you made the move from direct representation into impact work.
Yeah, I mean, one of them, for those of you who aren't lawyers, which I suspect maybe a number of you, although I don't know, there are a fair number of obligations that come with being a lawyer. If you're representing a client, you really have to do with within the bounds of ethics what will help that client. And if there's some systemic reason why that client's being treated unfairly or something else, you really, that's not your business. And You have to do what's best for that individual. And that's a really important thing, because people need advocates, but it also means that if you're doing direct representation, if you're a legal services lawyer or a public defender, there's a limit on what you can try to accomplish more broadly. And so one of the things that's been crucial about shifting from public defense work to the ACLU is that we can see problems out there in the world, and yes, it's important to connect to the people who are actually affected. So we're not just representing my interests in court. We have clients, we represent them, but in the case of the drug lab scandals here, where you had tens of thousands of people who are wrongfully convicted and no one was really solving the problem, there was no one who was identifying the people who were affected. There was no one creating a case list. There was no one who was assigning them attorneys. There was no one who was overturning their convictions. And so if you were doing direct representation work, the major problems, which was that the people were not being identified and provided with counsel and having their convictions overturned, you couldn't actually solve that problem, a problem affecting tens of thousands of people, through some regular direct representation, taking on one client at a time. So that was an example. It was a scandal that broke shortly after I moved to Massachusetts, of a situation where impact litigation, trying to figure out a way to tackle a problem, and then finding, working with clients who are affected by that problem, was really crucial. And I think, had it not been for the work that the ACLU did and the public defense organizations and law firms with which we partnered, I mean, most of those convictions, I think, would still be on the books today. And for those of you who don't know, when I say wrongful, tainted convictions, I mean, we had one chemist in one part of the state who was inventing evidence that was used to convict people of drug crimes by inventing lab test results, and another person who was certifying that people had possessed illegal drugs, and while she herself was high while doing the testing. So for those of you who didn't study science at Brandeis, that's bad. You're not supposed to do that. And so, these were huge, seemingly intractable problems that the sort of normal provision of legal services was not going to solve. And I think that's where it's really important to do impact work.
Yeah,
I hope that answers the question.
That it does. And I can definitely relate to that. I do direct representation, and we often have a client who we think it would be best for the client, and the client wants to appeal, but we're worried about setting a bad precedent for other people in similar positions. So in some ways, impact work is a nicer way to help a larger group of people. Tackey, I'd love to have you answer the same question.
Sure. I actually tried the whole hang your own shingle thing for a little bit while still working in the state Senate, and decided that wasn't for me. Did a little bit of contract law, a little bit of real estate law, dabble here and dabble there. And after like 3 years of this, I was like, I just not good at this self-employment issue. So through a winding road of state house politics, I found myself in the AG's office working in the Office of Repair Advocacy, which used to be called Energy and Telecom, which should be called Utilities. So I found myself neck high in utility and energy law to represent ratepayers at the Department of Public Utilities regarding proposals by utility companies on changing rates or customer service and things like that. So I found myself working for was essentially an invisible group. I was representing, almost 6 million people in the Commonwealth who are unrepresented before Department of Public Utilities. And one very important agency that actually nobody knew existed. And working very nuanced area regarding everything from accounting to electrical and gas physics and engineering to case law at DPU and federal case law and state case law. So it was kind of a trial and error situation to find out that it was best situation one, being employed by someone else. That turned out to be smart. And secondly, working in a government still, invisibly helping a lot of people and frankly being cool about that. So obviously I left that job to run for office. You can't be an assistant attorney general and try to fundraise. It's not a good idea. They don't like it when you have a badge and try to raise money. They didn't even give us badges. I wish we had a badge. But and needless to say, career change shift and opportunities are rare. And I wish I was in the AG's office just a few more years because not because the work was great, but also there was so much more to learn. And again, you can leverage this experience into the private sector as well. If I wanted to get into energy law or work for a utility energy company or a startup or renewable energy or any of them, it was a good chance to do so. But I decided not to make any more money and went into politics instead on the elected level.
And we're so grateful that you did that, that you chose to do that. Thank you. Let's turn to Karen.
Thanks. When I did finally decide to go to law school, it was clear to me that impact work was what I wanted to do.
Karen, you froze. She's frozen for everyone else, right? It's not just me. Okay, that's what I thought. I'll just give her like 15 seconds to see if she comes back. Okay, I'm gonna have, it looks like she disappeared. Hopefully she'll come back. We're gonna move on to the next question and hopefully we can swing back to her. Courtney, if you could try to reach out to Karen, that would be great. So the next topic I wanted to talk about is recent events and social justice movements. Can you all speak to whether and how your work addresses and intersects with some recent social justice movements, such as Black Lives Matter and general anti-racism sentiment? And I'd love to start with Tackey for that one.
Well, in my case, it's a little bit different because by nature of the position, I have some form of platform to speak from. And the responsibility of being a voice in your community that knows something about the community that you represent. The COVID situation made it extremely difficult, I think, for everybody. In my instance, for example, I live with my mom who has stage 4 lung cancer. So to say I was in the bunker big time through COVID would be an understatement. And the challenges of being not just an elected official, but being a good advocate for your own community and people of color, proved to be very difficult. You are not going to find me at a BLM rally under any circumstances, for example. The risk level at home is far too high to take that chance. So as a result, a lot of it's through communication and social media, signing on letters, being involved at that level. And most recently with the anti-Asian issues, it's been largely driven around educating people about Asian Americans and Pacific Islanders, which most people actually know very little about our challenges in systemic racism, as well as our history in the country that spans well into 200 years of the United States. So, some of the legal skills here involves a lot of being able to sift through a lot of reading and documentation. For example, looking at cases regarding citizenship and race status, from 100 years ago. You'd be surprised how many cases there are out there at the federal level that tries to define race and why is it relevant to Asian Americans in these cases. Not to say I read every single one of them, but I looked at a few. And we're working on things like hate crimes laws, again, to look at those things and reading those case laws. And obviously, as chair of this committee, I do a lot of work on Commerce Clause stuff, which is constantly coming through my committee. So, beyond the social justice stuff, I'm always involved in these other cases. But I think I know this is part of discussion as well, but it's difficult to do this work in a COVID circumstance because of other responsibilities at home. And this has been hard for me in a sense of prioritization of what needs to get done for who first. And for better or for worse, guys, I mean, mom came first this time in trying to get things done.
I think we can all relate to that sentiment. Thank you for sharing. Matthew, I see that Karen's back. That's great. We're going to swing back to you after Matthew answers this question, and then we'll let Karen answer both questions. So go ahead, Matthew.
Yeah, I mean, I would say that racial justice work is an enormous part of what the ACLU Massachusetts does. It's by no means simply me. We have a legal department that does a variety of litigation. We have a legislation department that works on legislation, including on things like police accountability. And we have a racial justice program led by Rasan Hall, who does enormous work in the law and in communities. I would say that one of the things that motivates us and one of the things that we work on is the problem that punishment and accountability are not evenly doled out by the legal system. When I was doing direct representation, the question that people want to ask you is sort of like, well, did your clients do it? And the truth is a lot of people do a lot of things. But punishment, the decision to prosecute them and the decision to punish them more severely versus less severely, those things are very much influenced by race. The certain offenses are regarded as more serious than others. Certain kinds of people are regarded as more threatening than others. And it's hard. It doesn't seem to be a whole lot of logic to it. But what is apparent is that people of color get the hard part of the bargain. And so that's something we've worked on quite a bit in our office. And it's happened a number of ways. We have brought cases about police accountability. We have brought cases about wrongful convictions. We have brought cases, particularly under President Trump, where it was bigotry against Muslims or immigrants that was the motivation we alleged for the practices. And it's, of course, the travel ban was the key example, where we brought a case on the Saturday night immediately following the announcement of the travel ban. But it was all kinds of cases, including the rescission of a program that helped immigrant families dealing with severe illnesses. So it's all kinds of things. We have also seen in Massachusetts, and for those of you who live here, who have a connection to Massachusetts, that state courts in particular can be huge drivers of racial justice, huge drivers of change in a way that federal courts often can't, both because they have some institutional constraints and also because, at least at present, the federal courts are very conservative. So there was a very significant decision in the Massachusetts Supreme Judicial Court, which is the fancy term that Massachusetts uses to describe its highest court, from a few years ago. And it relied on some work that our office did in noting that there is a disparate targeting of Black communities in Boston for police activity. And this is a case called Commonwealth against Warren. And one of the issues in the case is the man, Mr. Warren, had fled from the police when he had seen them. And the police accounted this behavior was suspicious and therefore a reason to stop him. And so this is a lot of what courts do. I mean, we think of this thing as just law, but really a lot of it is sociology. Going back to your question before about what drove me to the work, right? This is actually, it's described as a legal question, but it's actually a sociological question. When somebody flees from a police officer, is it likely to be because they are guilty of something and afraid of getting caught? Or is there a different reason? And the court said unanimously that there may be a different reason, which is that the person might be afraid of being subjected to racially disparate policing, which there is evidence actually happens in Boston. So this is a decision that was quite unusual and profound, which said that fleeing from when a young Black person flees from the police in Boston, this is not necessarily suspicious behavior that gives rise to a basis to stop that person, because that person might be justifiably in fear of racial profiling. So that's an example of kind of case that we worked on. In that case, we worked on it not as the lawyers, but as the people who supplied the report that was cited by the court. And it's a kind of, and it's also an example where courts, and in particular state courts, can make a huge difference when it comes to racial justice.
Thank you for sharing. That was a fascinating case I had never heard of. Great work. Karen, we're going to turn back to you for 2 questions. Let's start with the question we're on, which is, can you speak to whether and how your work addresses and intersects with recent social justice movements such as Black Lives Matter and general anti-racism sentiment? And then we'll go back to the question before.
Sure. So with my apologies, my computer started the day with a Zoom deposition first thing this morning, and I think it just the sheer no, like it was done. So here we are. You know, so the bulk of my work is really within the LGBTQ communities, and I say communities plural because I mean the truth is that there's no way to work for the full civil rights of one community in isolation. There is no community that is monolithic, and people don't experience discrimination in compartmentalized ways. So an intersectional approach to this work is just critical. And there's just also a reality of the ways in which different forms of bias and stigma and discrimination are all interconnected. So, for example, a piece of work that we were engaged in this past year, picking up on Matthew's themes of the ways in which the previous administration was really targeting communities of color in lots of ways, and without a doubt was also targeting aspects of the LGBTQ communities in lots of ways. And one of the manifestations of that was this executive order that basically prohibited federal contractors, federal grantees, from really conducting trainings of all things. Simply, if you receive money from the government in some way, shape, or form, what the executive order tried to do was prevent any of those entities from engaging in trainings, whether of their own employees or externally, in any way that acknowledged or confronted the existence of structural racism and sexism in our society. And what does that mean? There was literally a list of prohibited terms. You couldn't talk about critical race theory, intersectionality, implicit bias, white privilege. It referred to all of this as race and sex scapegoating and forbade agencies from doing anything that promoted these divisive concepts. So what did that mean? And why was this something that we jumped on? You know, our clients in this case were grantees and contractors for whom training on those concepts is central to their work in serving LGBTQ people and people living with HIV. These are healthcare providers of last resort. These are organizations that in the midst of the pandemic were out there trying to work with communities of color. These are largely aid service providers, actually, that were out there trying to ensure that folks were understandably reticent, given the history of abuses of communities of color by the healthcare industry, as it were, when it comes to experimentation and you know, you think about why there are folks in communities of color who would be, say, reticent to take the COVID vaccine. These were organizations that were doing trainings within the criminal legal system to ensure that Black and brown LGBTQ juveniles in juvenile justice facilities were not being disproportionately targeted for discipline. So we, and I should say, actually, I just alighted over work that is actually closest to me, which was an organization that specifically works on cultural competency training for LGBTQ older adults, pursuant to grants, to ensure, again, that folks who have lived lifetimes of intersecting discrimination based on their sexual orientation, their gender identity, their race, their religion, that these are folks who need access to care most critically, who are often facing the highest barriers to accessing it. So we challenged this executive order because of just the incredible ripple effects that this would and could have in tying the hands of the very agencies that are designed to provide the direct service, that are designed to help folks overcome those barriers, because the Trump administration didn't want anybody, feeling bad for the history of systemic racism and sexism that is embedded within the institutions of this country. So I use that case as an example, both because of the substance, but also because it's an example of partnerships. It's an example of partnerships across the civil rights communities that are engaging in this work. We brought a piece of litigation challenging it, as did folks at the NAACP Legal Defense Fund. And it was another opportunity for ensuring that different civil rights constituencies who may have closer relationships with folks on the ground in different ways are ensuring that the voices of the folks who are most vulnerable and most directly impacted are being represented and being addressed. So absolutely thinking about the ways in which LGBTQ people of color experience discrimination that is tied to their sexual orientation and transgender status or HIV status in a way that looks quite different from white folks is part and parcel of the work that we do.
Thank you so much for that very thorough answer and also very inspiring work. So the question when you had been cut off was about how you made the decision to do impact work and direct representation. Go ahead.
Sure. So I think what I was saying when I froze was that, I graduated from Brandeis not really knowing still that law school was the path that I wanted to go down. I had spent the summer before my senior year working for the Religious Action Center of Reform Judaism in DC, doing mostly civil liberties policy work. And it was the first sort of instance of working within a nonprofit doing advocacy work on the kinds of subjects that I was really passionate about. I graduated and then I went to work as a paralegal in a firm for a year, and it was a really important thing that I did because it taught me that yes, I liked the law, and no, I never wanted to work someplace where I didn't have any control over who my clients were in any way, shape, or form. We don't always control who our clients are, and we take them as they come, but it's a very different context. And I went to law school anyway, knowing really that impact litigation was where I wanted to go. I wanted to be able to do the system change work. And I had really great opportunities to intern in lots of great places. I worked for the ACLU New Jersey affiliate for a summer. I worked at the Brennan Center for Justice. I worked at what is now known as Legal Momentum, which at the time was now Legal Defense and Education Fund. And I graduated from law school actually without a job, moved to Massachusetts because of my spouse's career. And actually, Matthew volunteered for Sarah Wunsch at the ACLU of Massachusetts for a while until I found really just a fantastic opportunity, which was to be the baby lawyer at GLAAD. So really, my entire 20 years of being a lawyer has really been focused on system change work and impact litigation.
Great, thank you. We just have one more question for the panelists, and then we're going to move to audience questions. So far, we have two. Feel free to keep thinking on it, or if you have a question for these panelists, feel free to add it to the chat now. So our last question, which we're going to start with Tackey on because he already started to address this a bit, is the impact of COVID-19 on your client population and how the pandemic has changed how you've been addressing issues. So Tackey, go ahead, please.
Yeah, the COVID impact in my world is very wide-reaching. So we discovered a lot of things through COVID. Systemic, racism, we talk about a lot, but it's much more complicated people give it credit for. But we do have more concrete versions. So healthcare disparity was very clear coming through from COVID. Healthcare insurance disparity, very much so. Working condition disparity, very much so. And even accessing government services with no linguistic assistance is a huge problem that was really revealed, especially regarding unemployment benefits. Myself, not just myself, but the entire legislature, was really on the case about this with the governor's office and the secretariats about our constituents' inability to access government properly. And our dependence on over automation shows disparities in itself. It's not just necessarily about having internet access or computer access, but also having a system that actually serves all people. And as we move away from actually having human beings talk to you on the phone, it shows you the weaknesses in automated systems. So we were getting a lot of issues all up and down the board regarding the COVID impact. And we're going to see this going down the road as well regarding issues in housing and mortgages and landlord tenant issues, not just on residents, but also in businesses. There's going to be this massive ripple effect on the way. And of course, COVID had an adverse effect on the Asian community in particular, because our narrative was lost in the conversation. So on March 20th, the State House of last year, we had sounded the alarm that this wave of hate was coming inbound on us, especially since we had suffered the greatest economic impact first, beginning in January, in local and of overseas and foreign transaction businesses. I mean, there wasn't an aspect of an Asian business that wasn't impacted here locally or trying to conduct the business outside the state. But once COVID hit, the voice vanished overnight. And I'm representative in the community where invisibility is not always our fault. We always get blamed for being invisible, but that's not entirely true. It's part of the conversation of systemic racism. So COVID, in my world, is an avalanche of disparities that have appeared. And I'm only giving you like a small, 5 to 10 examples here. But, they are just enormous. And some things that we've done, we formed a health equity task force that my colleague Donald Wong was appointed to, and we talk a lot about how Asian Americans were not even part of the conversation in healthcare. If you look at the CHIA data on insurance, we don't even appear at all on the data sets. And if you look at the Mass Taxpayer Foundation's most recent report about disparities in government and funding, Asians don't even appear as a data set. So, COVID's really brought out a lot of these issues, and even protection in my end of the community. There was heightened awareness in places like Lowell, which has a large Cambodian community. The police was out and forced to demonstrate, they're not going to tolerate, attacks on the community. But down in Quincy, for example, it's silence on the city saying that we're not going to tolerate it here, and we will, have a presence. So you try to vandalize or break a window or attack someone, we'll be around. So this is kind of the challenge here in the Asian community as it relates to COVID. Again, it refutes a disparity of representation or front. There's we could do a longer conversation about Asian racism and all that. But what's interesting is that for the first time in the past 3 months, especially after the shootings in Atlanta, people know more about Asian people than they've ever known in their lives. And they're finally realizing we're not all the same. And I'm not using that in kind of the joke we all like to use, but I mean, literally, we're not all the same. And it's also resulted in a mobilization among Asian Americans realizing that any of us can be victims, much like the era of Vincent Chin. I bring up the LA riots. I bring up, the attack on Sikhs after 9/11 and other Asian Muslims after 9/11 that were attacked. So, there's this huge avalanche of disparities that COVID has revealed on all levels, not just in healthcare and unemployment, but also race and how we value certain demographics more than other demographics, and then we're pushed to the side. So you may have heard on social media, even the Hate Crimes Act going through Congress, led by Congresswoman Lane, Congresswoman Chu, and Tammy Duckworth, that Asians shouldn't get anything. Why should they? And it's actually an interesting point. And then, in issues of race, for example, why can't Asians lead a racial issue? There's pushback on that idea that Asians are people of color that can lead an issue regarding race. And this is something I have to keep reminding folks, because I'm the most senior person in Democratic leadership that's a person of color. but I trust you don't think of that right away when I say democratic leadership, person of color. Last thing is you think about looking like me. And again, this is an American cultural issue of systemic racism that Karen actually hit on the head. I don't sit here and accuse anybody of being a racist intentionally. Well, there are intentional racists, but I mean, mostly you don't think of things that you would think is racist or sexist sometimes, but it's there and it's in the system. And I live in the system more so than I think people realize, because when you look at politics and government, am I running this place? I'm just part of the system trying to work in this place. And this is kind of part of the larger issue about how people listening to yourself perceive the issue in COVID on so many different levels. And I'm still fighting hard to make sure it's consistently a part of the conversation in all my, light Asian people, brown Asian people, very dark Asian people, and the whole 9 yards. So when people say we're brown, to me, I think South Asians. I think, people from South America and Central America as Latinos, Latinx, Hispanics. I do not think that we're brown. And this is kind of one of the interesting problems about systemic racism that probably none of you ever thought about that, right? And by the fact that people push those words out there about consideration of us is inherently systematically racist. So that's kind of a simple example of how COVID kind of blew all these issues up on us on so many different levels. In many ways, I'm kind of battling a lot of interesting challenges simultaneously.
Tackey, thank you so much. I feel like we could have a full panel to discuss this. I have definitely learned so much just from your answer to that. So thank you for sharing. Karen, we'd love to have you address the question next.
Sure, thanks. I think Tackey hit the nail on the head that what COVID really served to do is highlight the vulnerability of the populations that we serve to discrimination and disparities. I think we saw, again, focusing on, for example, I do a lot of work with LGBT seniors. And as we know, the pandemic was already in many ways most deadly for older people, but was particularly challenging for LGBT older adults who, again, have faced a lifetime of healthcare disparities from a medical and mental health system that pathologized them and their identities for far too long, far too much of their lifespans. The research shows that LGBT older adults are much more likely to be more vulnerable for COVID in the first place. And that lifetime of discrimination at the hands of the medical establishment, while also being a cause of the disparities, also makes people less likely to seek care. We're talking about a population that is more likely alienated from their family of origin and for whom social isolation is already a huge issue, which was then compounded by the need to social distance, the closure of support programs, and disproportionately, folks who have less tech savvy and could not, say, for example, spend their day on Zoom or FaceTime or other ways of connecting virtually. So there are just ways in which it really compounded those vulnerabilities for the populations that we serve. The one other thing that I'll say was that in the midst of all of this, again, the previous administration then chose to remove explicit regulatory protections for LGBTQ people and people with limited English proficiency under the Affordable Care Act. So, in the midst of a time when the need to access healthcare and remove barriers was so critical, we were doing it in the midst of an administration that was just posing additional ones, and that absolutely affected the ways that we were able to serve the communities that we need to serve.
Thank you, Karen. Let's move to Matthew.
Well, I'll try to answer the question and maybe pick up a couple of questions in the chat. I also see that I think we're hitting the time when some people have to run, so I'll try to just briefly hit some of these points. So first of all, in terms of the pandemic, I mean, we've had many cases that have really sought to limit the spread of COVID in prisons, jails, and immigration detention, where people can't aren't allowed to engage in social distancing. So by I think it was March 24th of 2020, so right as the pandemic was really hitting, we filed our first case with the Massachusetts Supreme Judicial Court, asking it to change things like pretrial detention and other rules that kept people locked up at the very moment when it was becoming, deadly to be locked up pretrial on something. And so, but it was an interesting time. We filed the case, filed a number of briefs, and then presented the first telephonic oral argument in the history of the Massachusetts Supreme Judicial Court from this attic where I'm talking to you now. And that's the case that Myka mentioned at the outset that's now, we think, resulted in the release of some 6,000 people. And we've done a number of cases since then. And the hope is that maybe we're heading all in a good direction, and people, including vulnerable populations, will be more secure than they have been. But it does look like COVID on some level is going to be with us for a little while. And we have questions about things like, are they going to test people in prisons and jails for COVID? Because that hasn't been happening regularly, particularly in our houses of correction. So we have an argument at the Supreme Judicial Court on that coming up on June 1st. But I'll mention that this is also an example of a couple other things that are raised in the chat. One is about state courts. And yes, I think that partly for ideological reasons, state courts are going to be present huge opportunities, as the Massachusetts Supreme Judicial Court did in the group Goodridge equal marriage decision, but in other cases too, for state courts to really make a difference and to make huge precedents when it comes to civil rights and civil liberties. They can set the example for our federal courts, including our Supreme Court, about how to do things right. But the other thing is that state courts are less constrained. It's not just an ideological thing. They're less constrained by jurisdiction than federal courts. And so federal courts have certain limits. There's legal rules like standing and the like that limit the sorts of things that they can deal with. Whereas this case that I'm mentioning to you now that has resulted in the release of some 6,000 people, this was possible partly because state courts can sort of be problem solvers. You can bring a case to them and they can just craft a solution that changes how they run the lower courts in a way that really impacts people's lives. And often they can be more creative and more flexible than federal courts and the kinds of orders that they issue. I also saw that, and this is related to a question about what people, if you're not an impact litigator, what can you do? And I think that COVID provides an example there too. I mean, we've all had to dramatically alter our own lives. And, there's some piece of it now where we're hoping that with the vaccines and the reduced incidence of COVID, maybe we can get back to other things, to the things that we used to do. But maybe there's some things that we want to keep, like for people who, can't easily drive to places or get to places. For people who, if they were to attend a court hearing to support a loved one, they would have to miss work and lose their job. I mean, Zoom, remote access to things has really opened doors for people. And so, I mean, I think one thing that if you're looking for something to do, if you, and I'm saying this to you probably because you're here on the Zoom right now, and apparently you have a facility enough to do that. I mean, if you want to participate in your local government or participate in some aspect of, court procedure or your town meeting or whatever it might be, and your local government has made it possible for people to do that over Zoom during COVID, you can speak up and make sure that doesn't go away just because people can now get back to meeting in person. And I think there's, many populations for whom attending in person is not easy. And particularly if you find yourselves to be a member of such a population, I mean, this is the time to speak up and make sure that the access that we've all sought to achieve during the last year doesn't go away.
Myka, if I could jump in on a couple of things that Matthew just said. So I am in complete agreement on both of those particular issues. One is about the state courts. So Goodridge was the first case that I ever took to the clerk's office to file. That was how I started my legal career. And among the reasons that we filed Goodridge in state court were some of the reasons that Matthew highlighted for sure, but it was also at a time when the federal judiciary was not a place that advancing LGBTQ rights was a particularly hospitable place. We were still living under Bowers versus Hardwick, which was the Supreme Court case that said that criminalizing same-sex intimacy was perfectly constitutional. So state courts, I think, yes, absolutely have the flexibility to do good things and sometimes issue things like advisory opinions or have access to more flexible tools, but they also are able to interpret their own constitutional provisions more flexibly and more expansively than sometimes federal courts can with the federal Constitution. The federal Constitution is the floor, not the ceiling. And there are ways in which the Massachusetts Constitution, for example, its Declaration of Rights has been interpreted more expansively and more flexibly. And I think that's true in many instances throughout New England, but other places across the country as well. And as we have seen shifts in the federal, incredible packing of the federal courts by Trump. I think lots of us who do impact litigation for progressive causes are absolutely, I'm old enough to have been doing this work long enough that I've done this before. We worked in state courts before, and some of my younger colleagues are like, what are we going to do now? And federal courts are absolutely not the only forum where there is incredible opportunity to do good things for the populations that we serve. The second point that Matthew made that I wanted to echo, and I'd be really curious to hear Tackey's thoughts on this as well, is I will also say that the ability to engage in the system virtually and electronically has also been tremendous when it comes to advocacy before state legislatures. We've seen a rash of really horrific legislation being introduced across the country, particularly targeting transgender youth, and the ways in which folks previously faced incredible barriers to participating in a legislative process because you'd have to take off work, and if you couldn't do that, then you couldn't testify, or you'd have to travel. You couldn't have childcare. There were all of these barriers to participating in the process that we have seen people's voices being elevated in ways they never have before because they could testify virtually. And I think it has been a really critical tool for bringing voices into these incredibly important public conversations that really could never participate before.
So you brought us some good questions, Karen, about the public process. As a committee chairman, one of the big challenges in COVID was pivoting our entire life to COVID Zoom, COVID Microsoft Teams, COVID WebEx, COVID Meetup. I have more apps on my phones than I never thought I would never use in my life. And one of the challenges, of course, is having consistently same app to use for all my meetings. And obviously we're using Zoom here, but this is like the real battle, right? What is the so-called secure platform we're going to talk about using? But you're also absolutely correct. This has been a boom in terms of public testimony. It's actually a boom for more geographic diversity for members under the boards or quasi-commissions and so forth. It has been easier for people who have disabilities or the seniors or the health conditions to participate as a member of the Board of Registration, as a member of a quasi-commission, works both ways. The public can engage, but also it encourages people to participate in these governing bodies in a large geography. So they're not stuck with everybody on the Board of Electricians comes from Boston, for example. You have them diverse around the state to do that. And it's something actually is an active conversation we're having in the legislature with the governor's people as well about how we should continue at some level the Zoom format. On the flip side, I miss being in person running hearings because the optics of meeting someone on a video call is terrible. Because if they go bonkers on you and start swearing and get nuts on you, I don't have a gavel to gavel you down anymore. It's actually kind of an interesting quandary we're trying to resolve at my level because I don't have by invitation public testimony. It's open game, literally. So it's a really hard balancing act right now about pre-sign up versus walking off the street. And I've chaired many hearings where people walking off the street, no joke, just walked in after a coffee and just wanted to testify. And this format, we don't have a structure going into it, can cause some real challenges. And I don't have answers for those challenges yet. We're doing a whole lot of trial and error to see what happens. Regarding the court issue, I agree with Matt and Karen about state courts. They're essential because of the separation of powers. And being very selfish as a state legislator, I want a conservative court to give me as much state rights as possible, which is kind of ironic, right? Because I don't like this Supreme Court. But state rights gives me as a legislator considerably more power than having a federal preemption issue. And those of you who go to law school know there's all kinds of things like, I talk about Commerce Clause and Dormant Commerce Clause, which is a big part of my life as committee chair. But the ability to run elections, as you've seen in many states, cuts both ways, where you have Georgia and other states trying to restrain election rights. Well, we here are looking at our constitution about expanding mail-in ballots and trying to figure out what we can within the constitutional constraints of the state, or we're going to have to amend the Constitution about mail-in ballots. This is a conversation we don't actually have a clean answer legally for anybody. Same thing on the governor's executive powers. The governor's using executive powers in the Wars Act to suspend general laws, which allows certain things to happen. So, for example, in my world, outdoor seating, patio seating, which many of you have been enjoying in restaurants, terminates 60 days after the end of the governor's state of emergency on June 13th. And this is actually pretty important for people I discovered. But question, if the governor's powers to suspend laws exist within the War Act, and you have something you want to suspend a law for 60 days after the state of emergency when the War Act is not being used, can you do that? I don't have a clean answer. You can cut it both directions, but welcome to being a lawyer. And some of the things you instinctively think is yes, instinctively think is no, may be a cloudy maybe situation, of which as chair of this committee and an attorney and talking to my own counsel and talking to governor's people and talking to my co-chair, which is also an attorney, and I'm rolling through like 7 different attorneys, all which gave me 7 different answers. So, I'm just selfish. State legislator, like state powers, pretty straightforward. Until you hate us and then you want federal preemption.
I love thinking about the mute button in different contexts. I represent mostly domestic violence survivors. So for us, it's been a real treat to have judges mute the abuser who's screaming obscenities either at me or at my client during court. But I hadn't thought about it the other way, that it could look bad to mute people. So we are gonna, I'm gonna go through some questions we haven't answered from audience members. If you still have one, feel free to unmute yourself or to type it in the chat. Also for these questions for the panelists, it's just, these are optional. So just jump in if you feel like answering it, and you don't have to if you don't want to. So first question, how do your identities, however you define your identities, impact how you navigate the legal fields and the work that you chose to take on?
Okay, I'll take that one first. My joke is don't wear a blue shirt at Best Buy. Trust me. First thing happens when I wear a blue shirt at Best Buy does not work in my favor. So I kind of alluded to this earlier before about systemic racism and the preconceived notions of what you do. And I think you heard what year I graduated Brandeis, and the continual misconception is exactly how old I am and how long I've been doing politics. Comes up every so often if you don't know me well in government. And no, my identity is pretty straightforward. My name is Tacky, for Pete's sakes. It's not like I have a lot of hiding spaces here. So it's working through the fact of quote unquote, you have to work for not your people. You've heard this before, obviously. You have to be, not un-American. You have to be these type of person to be a elected official. And despite all those kinds of concepts out there, I'm still me. I mean, I try to do my best. I try to be polite. I'll be mean sometimes because it requires being mean. But it's overcoming a stereotypical profession where it's not just about all white guys. I mean, it's other folks. And now I have female colleagues that are also Asian American. There's always that challenge of that stereotype too. The misogynist concept against Asian women. And the thing is, it's actually not in the legislature. Our colleagues that are elected aren't bad. And the reason is because we all had to get there the same way. Everybody had to win an election. It's dealing with the public more than the government, more than lobbyists, more than people in government with us in the legislature. It's the general public, the outside point of view on us on the inside, and the misconceptions they have about individually all of us. And even as simple as the fact, they assume I'm good at math. Yeah, we went to law school. We're not good at math, but these things that like they assume that I'm good at. But conversely, when I move into areas where they are surprised I know this much about this topic that you would think an Asian wouldn't know, despite that I grew up with Irish and Italian kids my whole life. They all look at me like, how could this be possible? And same thing in my own Asian communities. They always look at you like, you're not white. I'm like, no, I'm not. Neither are you. So get over yourself. And it's kind of a interesting dynamic I deal with so many different facets of different communities that I'm always kind of like trying to figure out what their problem is. And one of the things that's most interesting about my life in the State House is the fact that other Asian ethnic groups that are needing voices, gravitate toward me, whether I want to or not. And it's because they think I will understand their plight. And oddly enough, I actually do understand their plight. So I do a lot more listening than talking most days when I see folks. And these are Asian ethnic groups that don't always like each other either. Don't get me wrong. It's not like we're all big kumbaya here. But they do feel it's important to have someone listen to them, understand what it is. And I do carry those thoughts and feelings through my entire policymaking process. That sometimes other people don't have that opportunity to have that very unique input.
So I think that's a great question about navigating identity issues. So I say that as a straight white cisgender woman who has been working in LGBTQ rights for 20 years and navigating privilege and navigating the importance of safe space. There are clients and judges and colleagues and opposing counsel and co-counsel who, all make various assumptions about who I am and what my identity is because of the work that I do. And, at the end of the day, it actually loops back to where Matthew started, which is that as, an attorney who represents clients, it's my client's story and my client's identity that is what I'm there to tell and represent time and time again, and ensuring that I'm doing that in the most zealous and ethical way. It means, as Tackey just said, I do a lot of listening and I do a lot of learning and I do a lot of absorbing, and I continually am conscious of and aware of places where I have privilege and where that can be frankly to my client's benefit, and where sometimes it is not. And it is about ensuring that my clients, I can remember vividly, I had been representing this woman in a custody battle. She was a non-birth parent of two children. Well, she was non-birth parent of one child and was in a custody battle with the birth parent. And I had been representing her for, at this point, a good 9-10 months. And we were sitting there in a conference room during a mediation, and we were waiting for the mediator to sort of come back into the room. And we were just sort of, casually chit-chatting. And she, started asking me questions about, just my personal life, just, really casual conversation. And I had that moment of like, I'm going to need to come out to her as straight because of the questions that she's asking me. And how is that going to affect our lawyer-client relationship? And how is that going to affect her sense of trust in me as an advocate for her? And is that going to sort of bust up her sense of safe space with me and her, the ways in which, Tackey was just addressing the realities of sort of shared identity. People will seek you out as a way, because they need to be listened to and think you're gonna be a more sympathetic ear. And I don't want to destroy that for people, but I also need to be honest and approach that with integrity and sensitivity to ensure that my clients continue to work with me in the way that is going to serve their interests best. Because at the end of the day, yes, I do impact litigation. The goals of my cases are not just about the individual client that I represent, but the broader folks who they are standing in for to address whatever the systemic issue is. But they're the real life human beings who are putting their stories on the line and their lives on the line to do that work. And it's the duty that I owe to them that I am always thinking about as I navigate exactly those identity issues.
Thank you. I think the only other question that hasn't been answered yet, which is directed at Matthew, is do you think that in the jurisdiction which opine that running from the police is not by itself suspicious because a person could fear prejudicial policing, would the court be more likely to uphold a stop or arrest if a white male were to flee from the police?
Well, I don't know exactly what a court would do. I think that first of all, that's a really interesting question. One thing I would
it's
say
from my dad, so I'll just take credit. Same mind,
one thing I would say is that this was going back to my point that this is a sociological assessment. This was the court's assessment of the reasons why someone was running. So it didn't require the court to conclude that the person had in fact been the victim of racial profiling. It was side of many considerations, including the evidence of racially disparate policing in Boston. Concerns about racial profiling could have been a motivation for someone to run from the police. And so that's just making an assessment of the person, and it has to be based on the individual. Yes, this person was a Black person, and that was relevant in the court's view to the decision-making process, but it's not necessarily the case that this would be a consideration that would affect only Black people. So for example, I saw another comment in the chat about disability. I mean, a lot of the things instances that we see of mistreatment or police violence have to do with people who are suffering from mental illness or who are having other issues, and what they were hoping to get from the police was aid or assistance, and what they end up getting is a violent takedown. And I represented a white woman who had that happen to her when she was suffering the effects of her bipolar disorder. And so one of the issues in that case is whether the police were sort of justified in regarding her behavior as being resistance, when in fact it was the consequence of a medical condition. So what I would say, I mean, this isn't a direct answer to your question, and partly because I'm not a justice on the Massachusetts Supreme District Court, but partly what I'd say is that courts have to be sensitive to all the reasons why people do what they do, and this is not a duty that applies to courts only when they're dealing with people of color. It applies to everybody.
Well, one of the things I instantly thought of when that question came up, actually somebody, one of my colleagues who's here observing this panel had shared a statistic with me this morning that police are much more likely than people in the general population to rape people while on duty. And so one of the instantaneous thoughts I had was, as a woman, do we want to be near police officers? Are we right to be suspicious of police officers as well? So I agree, it could really apply to a lot of populations and just different people's ways of thinking. I think that we've reached the end of the questions. If anybody feels like their question in the chat wasn't fully answered, feel free to let us know. If people want to come off of mute and and talk to the panelists or ask any more questions, we'd be happy to hear from you all.
Thank you all very much. Take care.